Construction. Okay.
Yeah.
So you've been basically your entire career focused on the construction industry.
That's correct.
Have you been engaged as a testifying expert before?
Yes, I have.
And you're paid for your time, correct?
That's correct.
Have you been engaged on both plaintiff's side litigation as well as defense side litigation?
Yes, I have. That's correct.
Do you have an idea or of a percentage of the mix where you were representing the claimant versus the respondent?
I don't know off the top of my head.
Do you have an idea about how many cases where you've testified?
In trial or arbitration, 11 previous to this one. 8 arbitrations, 2 in state district court, and 1 before the administrative judge for TxDOT.
Okay. You were engaged by Canterbury Cove Homes in this litigation to assist in a delay analysis. Is that right?
That's correct.
And what were the types of materials and information you looked at to determine if you had any opinions for this litigation?
There were documents provided by the client, by Canterbury Homes, various pleadings, depositions of from THB representatives and their exhibits. Excuse me, there was a document with THB's claim delays, which categorized several delay areas and a detailed listing of their claimed weather and dry out days. Looked at some miscellaneous drawings, change orders, and pay applications.
Are those the type of materials and information that a person in the construction industry would typically look at to determine whether or not there were proper delays or to render a delay analysis type opinion?
Those are some of the documents that we would normally look at. I would definitely say that wasn't the full complement of documents that would be required. Typically, we would expect to see schedules, delay analysis, or some sort of analysis to support the claim delays. And we saw none of that in this case.
Okay, but my question is a little bit different. As a person that does the types of claims analysis, are those the types of materials generally that you looked at in this case that the type of person in your reasonable person in your position as a claims director would look at in the field?
Yeah, to do our job, those are the types of documents we will review. Yes.
Okay. Do you believe that did you render opinions in this case?
I did.
All right. And do you believe that your opinions were based on your specialized knowledge, skill, and experience?
Yes. I mean, based on my career and work performed, all of that combined allowed me to make the opinions that I made.
And do you believe that the methodology you employed and the materials you reviewed are consistent with what those in the construction field would also look at?
Yes.
Okay. You issued a report in this case, correct?
I did. That's correct.
All right. I'm going to bring up Exhibit 118 because it's been admitted here. So we just short circuit some of this, hopefully. Can you see that?
Yes, I can.
All right. And this is a copy of your report that was prepared for as a summary of your opinions, correct?
That's correct.
And on page 3 of your report, there is a general bullet point list that references a summary of your opinions. Is that right?
That's correct.
Okay. And can you give the court just don't read this to the court, but can you give a thumbnail sketch of generally what your opinion is with respect to the delays associated with the Canterbury Cove project in this case? Yeah.
THB failed to meet any their contractual requirement, 1, to provide proper notice, and 2, to provide proper supporting documentation for the delays that were claimed. There was one of the claimed areas, the outfall structure, where there was a change, the junction box and outfall structure, where there was actually a change order written and executed with no reservation of rights. The other claimed delays, with the exception of weather, there was no evidence to support that a proper analysis had been done or the proper supporting documentation had been provided. I did agree that there was excusable time for 52 calendar days of weather, excusable, non-compensable. There was documentation supporting weather that occurred near the site, not necessarily at the site. THB at the time of their termination, they were 371 calendar days behind the project completion date of April 15th. Based on the liquidated damage rate of $750 a day and that completion date, the liquidated damages were calculated at $278,250.
Did you have occasion to look and review at the email that was, well, you were here watching the testimony earlier this morning, correct?
Yes, I was.
Okay, so you saw both the email during that testimony as well as reviewed the email before you rendered your report where THB provided a completion schedule to Canterbury Cove, correct?
Yes, I did.
Okay, and what was your opinion of that email with respect to the projected completion date of this project?
I mean, based on that email and reading the prior email below it, that was THB's planned completion date for the contract.
Okay. Did you see in your review of materials any, quote, project supplements?
I did not.
All right. Are you familiar with the term project supplement with respect to the construction industry?
Yeah, it's a term I see it quite often.
Okay. Were you surprised that there was not a formal project supplement in this case?
I would have expected to see one, yeah, but it's not uncommon that we don't see one.
Now, one of your opinions relates to THB not providing supporting data to justify its delays. Is that right?
So can you restate the question?
Yeah, one of your opinions relates to THB not providing support or data or written documentation justifying its delays, correct?
That's correct.
Okay, what's the basis in the industry practice for that opinion?
Well, in order for there to be, I'll back up. Every project, there is a critical path to the flow of work on the project. And whether it's documented in a schedule or a bar chart or a network diagram, every project has a critical path. And what that critical path is, that is the flow and sequence of activities that is, uninterrupted, is the longest path through a project and drives the project completion date. There are other paths or streams of activities within that schedule that aren't necessarily on the critical path. So that's, what those are considered to have flow. The theory behind a delay to a project is the critical path of the project has to be delayed in order for the end date of the project to be delayed. If an activity that is on a activity path that has float, that activity can be delayed without exceeding the amount of available float and not have an impact on the completion of the project. So you can have a series of activities that while they get delayed, they're not critical or don't become critical. Therefore, they don't impact the overall completion of the job. And an analogy of that is if you have a tent with 3 poles in it, 2 of them are shorter than the third, that long pole in the tent is what's holding up the highest point of that tent. So that's the critical pole or the critical path of that tent. Either of those other 2 poles can be pushed up or down with no impact to the overall height or the end date of that tent or the end date of the project, if that makes sense. So in order to substantiate a delay to the project, you've got to be able to show there was an impact to the project's critical path or impact to activities that became critical and impacted the project's critical path. That's the industry standard for identifying and quantifying delays. And then that's broken down into, the other piece of that is, even if there is a delay, there's got to be entitlement shown that the contractor is entitled to recover for that delay, or that he wasn't at fault for that delay. And any claim delay claim delay issue, there has to be a causal relationship between that issue and the activities being affected that drive the critical path. Okay. Those are all things that make up a proper delay analysis, which is required to support a delay claim.
Okay. And did in this case, did THB provide any evidence or justification for the delays affecting the critical path, separate and apart from the rain delays, the weather delays?
No, they did not.
Okay. And was it your opinion that the quantification of the rain delays as presented by THB to Canterbury before their termination were sufficient to justify the delay beyond the completion date?
No, actually, I did not think it was sufficient to quantify the delay, but based on correspondence from the owner that he believed there was impact caused by the weather, I felt that it was, and it's reasonable to expect that type of delay. So at that point, I said it's reasonable to assume the 52 calendar days would have impacted the critical path and allowed that time.
Okay.
It was a conservative analysis.
Okay. But it's possible that if you were taking a more aggressive analysis, because it wasn't contemporaneously supported with proper documentation, the entire amount of the weather delays would be not allowed as an excusable delay.
That's right. I mean, THB did not prove critical impact to the project because of the weather incurred.
Okay. On your page 6 of your report here, there's a summary of the different claims.
The court reporters having, and I am too, but the court reporters having a lot of problems hearing this witness because of static. I don't know what his connection is like, but it is hard to hear him. Tony, are you hearing him okay? It seems like you just sent me a message that there's a lot of static.
I am hearing him, but I'm kind of having problems. It would be smoother if I could hear, if it wasn't so much static.
Hey, Mr. Holstead, why don't you step or back up from your mic a little bit? It seems like as the louder you are, the heavier the interference. Maybe that'll help.
Is that better?
A little bit.
Yeah.
Okay. I apologize. I do have a bad connection in our office.
Okay.
All right. And I think, fortunately, I think I'm almost done, actually, Your Honor, but let me run through this real quick. With respect to the junction box excuse of 27 days, do you see that here on page 6?
Yes, I do.
Was there any evidence or written documentation provided by THB that would explain how having to wait for a junction box to be serviced on the property impacted or interfered with the critical path to the completion date?
No, there was no documentation provided to support the 27 days claimed.
Okay. And it could be the case, the reason the critical path issue is so important is it could be the case that there would be other portions of the project that they're working on to get to the completion date while they're waiting for the junction box to be installed or manufactured or whatever the issue was.
That's correct. I mean, phase 1 was approximately 10 acres with around 4,000 lineal feet of paving. Without some type of analysis or even documentation to show what portion of that work was being impacted, there's such an area and an order of magnitude of work that could have been performed that it's very likely that the critical path was in another area of the project. It was progressing even though there were delays associated with the outfall structure in that specific area.
Okay. And though, just so the court knows this, on your report here, CDs, that's calendar days, correct?
That's correct.
All right. And so the same is true for the franchise work and the power pole or encore. There was no evidence provided that interfered or impacted the critical path towards completion, correct?
That's correct.
Now, with respect to the stop work order or the SWIP violation, was it your opinion that was the fault of THB?
Yes, that's correct.
And so because those are delays caused by their conduct, they don't get credit for them. Is that right?
That's correct.
Wait, which days were caused by their delay?
The city of Rowlett stopped work order for 11 calendar days, and the SWIP violation, which is their responsibility to maintain the SWIP program, that 1 calendar day.
And as a result of the analysis that you did, taking the liquidated damages number from the contract directly, you just came up with a simple calculation based on unexcused delay calendar days multiplied by the 750, correct?
Yes, the unexcused days late beyond the adjusted completion date of June 11th times the 750, correct.
That's a good point. I'm glad you said that because I didn't talk about the adjusted date. The original completion date, as you understood it from the emails, was April 15th, 2019, correct?
That's correct.
And then you gave them credit for approximately 52 days of rain days, correct?
Correct.
And so there's an adjusted completion date for your delay analysis of June 6th.
Yes.
And then the time period between June 6th and the determination is 371 days.
That's correct.
All right. And the math from there, because this is a $750 a day damage provision under the contract, is $278,250.
That's correct.
All right. Thank you. Pass the witness.
Any cross?
Yes, Your Honor. Now, sir, were you told by counsel for Canterbury to assume a completion date of April 15, 2019?
I wasn't told to assume a completion date. Through conversation, it was my understanding and reading the correspondence that was the date prepared and transmitted by THB to Canterbury, that was the date they were going to be completing the project.
Okay, so and again, you're referring to the email from Mr. Boney that you referenced that we've seen today as the exhibit, correct?
That's correct.
And you've seen no other documents to support a completion date other than that email, correct?
That's the only documentation I've seen that showed a project completion date, which was April 15th, correct?
And you've seen no project supplement, correct?
No, I have not.
Which surprises you that you did not see a project supplement with a completion date?
I wouldn't say surprised. I would have expected to see it, but to say I was surprised, no, it's not. I mean, I've seen stranger stuff.
If there is not a completion date in the...
Let me talk to the witness real quick. So, because this is a key issue, I think, in this case. So what do you usually see when it comes to project supplements? How are they usually something titled project supplements, or how does it usually work?
There will be, yeah, I mean, typically, there will be supplements. It'll be, or usually they're called exhibits. I'm used to seeing them as exhibit A through J or whatever to the contract. And when I say I'm not surprised, I have seen contracts that reference a certain number of exhibits that don't exist. They were never prepared, they were never included. So this job's a little different. I'm used to seeing actually the contract completion date typically is in the body of the contract itself. It's usually not in a supplement.
When you have a project supplement that's not prepared at the same time as the contract, how does that usually work? Or have you ever seen that?
I mean, it would be incorporated via change order. It would be what I would
So
expect.
it would be like a change order then.
Correct. To an amendment to the contract. That's correct.
Okay, go ahead.
And in fact, this contract states that, a change order can be considered a project supplement, correct?
I don't know. I don't
Okay, all right.
I
Okay,
just don't recall.
sure, I'll move on. But again, if there is not a completion date for this particular contract, then the liquidated damages provision does not apply because it's triggered upon a completion date, correct?
That's a legal interpretation that I don't know that I'm qualified to answer.
Okay, but you wouldn't know how to do a calculation of liquidated damages based upon days after it's supposed to be complete when there's not a completion date to start with, correct?
There's got to be a basis to do that calculation.
Right, because your calculation you have today obviously has a completion date, and that's where you start the day after, I guess, you start your calculation of the $750 a day.
That's correct.
Okay, and so without that start date, you don't have, one of the two numbers to calculate the actual damages under the contract, correct?
Right. There needs to be a basis to start that calculation.
I'll pass this.
Just a couple of questions, Mr. Holstead. You understand that this contract does have an Article 9 related to delays and timing, correct?
That's correct.
And it was your understanding that the contract called for that time was of the essence?
That's correct.
And does that typically impose an obligation on the contractor to work with dispatch and diligence to complete the project?
That's my understanding, yes.
In this case, this contract required the contractor to provide a schedule for completion, correct?
That's correct. I think in Article 9.1.
Yeah, and also I think in Article 2.2 or 2.1, correct?
I can't remember the exact number.
Let's just look at it just to make sure. To show you. Can you see that?
Yes.
2.2, contractor shall prepare and submit an estimated progress schedule. You see that?
I do.
And that's after commencement, correct?
That's correct.
So they would have already started working on it. They're supposed to provide a schedule, right?
That's correct.
And the contract documents include things like all project related addenda and modifications incorporated or expressly made part of the documents, right?
I'm sorry, where do you see that?
Up here in 1.13, the definition of contract documents.
Yes.
And it also includes modifications and change orders made pursuant to the terms and conditions of this contract, right?
Correct.
All right. And the email that was sent after multiple requests from Mr. Reader to Mr. Boney on January 19 provides a schedule, correct?
That's correct. I think that schedule was provided in, as part of the obligation of the contract to provide a schedule and identify a contract completion date. They only relied on that schedule.
And does it make any sense to have a contract with a delay provision, time is of the essence provision, and a liquidated damages clause if the contractor can just simply avoid all of those provisions by never giving a completion date, even though it's their obligation?
No, that makes no sense. Nor does it make sense that THB submitted documentation to support the delays if there was no project completion date.
Okay, no further questions.
Hayes?
Sure, let's just a few follow-up. If you can go to Exhibit 3.
Yeah, let me turn this off for you. There you go.
Okay, yeah, Maddie will do that. So I'm gonna go to 2.2. And I believe council had referenced the previous question to you about 2.2. 2.2 references estimated progress schedule. Do you see that?
Yes,
That's not a completion date, or that's not a definition of completion date, is it?
no, it's a requirement for a schedule that would provide the completion date.
But it doesn't then reference any completion date in that. So a progress schedule in of itself, sir, is not a completion date under this contract as you read it, correct?
In my mind, the progress schedule identifies the completion date. That's the purpose of a project schedule.
But sir, you're aware in the construction industry, there's often progress reports, progress schedules that are sent out to advise the owner or contractor, hey, here's where we're at in the work.
That's correct.
Okay. And 2.2 could have added this estimated progress schedule constitutes a completion date or project supplement, correct?
I'm sorry, can you restate the question?
Okay, sure. The paragraph 2.2, that provision, it could have easily been added that estimated progress schedule, in fact, is a project supplement and that provides a completion date, correct?
Sure, it could have said that.
Yeah, it doesn't say that. And the mere fact that there is some language in this contract that refers to liquidated damages relating to a completion date, that doesn't mean that the contract has a completion date, correct? It's just, here's a scenario. If there's a completion date, here's what may occur in terms of damages. Correct?
I mean, no, technically, it does not say that there's a completion date, no.
Okay. I'll pass the witness.
Nothing further, Your Honor.
Okay, call your next witness.
The plaintiff rests, Your Honor.
Defendants, call your first witness.
Sure, let me just check just a sec on scheduling.
Oh, and I just want to let you know, I did send a link over to Rhonda for the trial proceedings tomorrow. If do you think we're going to go into tomorrow? That I have to break at around 4, a little after 4 today, but we have a lot more left.
We're just going to call Mike Boney right now, and then we're going to call Travis Boney. But I don't think Mike Boney will be more than 30, 40 minutes of direct.
Okay.
Yeah, I think there's a chance we could finish today.
Maybe what we do is just try to get the testimony in today, and then we'll do closings tomorrow morning. But we'll see how it goes.
Yeah.
Okay, let me get legit.
Sir, go ahead.
Mr. Boney's in the same room. I'm going to ask him to identify himself and make sure everybody can hear. Could you state your name, please?
James Michael Boney.
No, it's not good enough.
Can you hear it, Tony? I can barely hear him.
No,
Can you put him in another room?
We're about to. This may work. It's just a second. Okay, let's try this. Can you state your name?
James Michael Boney.
Yeah, that's better.
I'll have him speak louder, but if that's not working, we'll move him to another room. So, again.
All right,
state
sir,
your
please
name
raise
for
your
the
right hand. I need to
James
swear.
Michael. He's talking to me.
Okay, I need to swear him in. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth? Sir, you need to keep your hand up, sir. Sir, you need to keep your hand up. Let me start over again. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I'm sorry about this, Judge. One more shot by Mercedes, and we'll move you to another room.
Hope you separate further away from the table to work better.
We can't have two of them going at the same time.
That's your favorite.
Yeah,
That's your
you guys need to be in different rooms.
One last shot.
Yeah, that's horrible.
Okay. I want you to go and take that, so. Take a look, so. Yeah, take a look. Yes.
Your Honor, if it's okay with you, I'm going to step down the hall for like 1 minute to use the facilities while we wait for Mr. Boney.
Okay,
I'm sorry. I apologize about this. Get it going.
Matter what's happening? Let's do the other side.
Your Honor, can you hear us okay?
yep.
Sorry about that.
Oh, no. Technology is.
Tony, you doing okay?
Yes, Judge.
And just a reminder about tomorrow, we do have a status conference on the Hume case at 10, even if we finish today,
Okay.
to deal with Mr. Buchanan's passing.
Mhm.
All right, Mr. McCafferty, are you ready?
Ready to go, Your Honor.
Let's try again. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I did.
All right, let's proceed.
Sure. You can state your name for the record.
Yes, state and spell your full name for the record.
James Michael Boney.
And do you have a position with THB Construction?
Yes.
What is that? Please describe.
I'll try that again. Yeah.
Can you describe your position with THB?
I'm a consultant with them and general manager today.
What types of things do you presently do for THB?
Well, coordinate their employees, do the day-to-day business.
And what is generally the business of THB?
We mostly do new subdivisions.
If you can just briefly go over your background in the construction business.
I've been doing this my whole life, I guess. I started out with my dad. He had a little concrete division, and I went to college for a while. Started a construction business. I've had a concrete construction business ever since I was probably 22.
And do you know Mark Reeder?
I do.
Do you know his dad, Ted Reeder?
I do.
And you've been listening today. We've been referring to the Canterbury Cove project. Your role been in that project?
I've been involved in the project from day one.
And just be a little more specific on what types of things were you involved in on that project?
I helped oversee the whole job as far as they had some issues at the first on quantities and some dirty issues and some just quantity issues on the plans. The plans had some issues with them, and from there on and, you know, through the completion part of it.
So has your involvement been such that you're generally aware of what is occurred on the project?
Generally, yes.
Okay. And just describe just generally what the project was.
It was an open field when we started, backing up to Lake Ray Hubbard. I think there was roughly 100 and something lots. They did it in 2 phases. We did the dirt work out there starting November. And it was to be a residential lot subdivision in the city of Rowlett. Single homes.
And if we could go to plaintiff's exhibit number 3. You just go to the first page. And are you familiar with that contract for phase 1?
Yes.
Okay. From
Is he frozen?
Your Honor, I believe he is having some technical difficulties right now.
You want to take over, Ms. Hayes? I'm just kidding.
Your Honor, can we have a quick 5-minute recess?
Yeah, why don't we take a quick 5-minute break?
Thank you,
problem.
Your Honor.
Oh, he's off the screen, actually. Okay. All right, we'll reconvene at 2:15.
Thank you, Your Honor.
All right, are we gonna get started again?
Yes, Robert.
Yes.
Okay, let's get started. We've had some technical difficulties, so let's move.
Okay. Okay, we've got to look at Exhibit 3, which is the master contract for Phase 1. You've reviewed that contract, Mr. Boney?
Yes,
Okay. And did you have any understanding that there is a specific completion date for that work under that contract?
there is not.
Were you involved in?
I couldn't hear what he said.
Yeah, no, there is not.
Were you involved in any discussions with anybody from Canterbury before the agreement was signed?
I'm sure I was to a point. Travis and them kind of handled this contract together.
Were you involved in any discussions with anybody at Canterbury prior to the contract being signed regarding a completion date?
No,
Is it typical that contracts that THB has and works on have completion dates?
no, they're not.
Why not?
Most subdivisions don't have completion dates in them. There's so many variables in their jobs and breaks and different subs in and out. So we don't have, I bet we don't have 1% of our jobs have actual completion dates on them, hard days.
You've heard during today the word project supplement. Are you aware of any project supplement document related to the contract for Phase 1?
No, I'm not.
Okay. Let's go to Exhibit 85. And the top part of that is an email from you to Bart. Is that correct?
It is.
Okay. And you have set out in that some dates. Do you see that?
It is.
Okay. Why did you send this email to him?
Bart asked for some scheduling and those are the scheduled dates that we came up with best at that time.
Okay. And did you intend in any way that what you provided him would be a completion date as defined under the agreement?
No, I did not.
Is it common or uncommon to send estimates of scheduling to owners or contractors in a construction contract?
It is not uncommon.
Okay. And what's the reason for sending estimated scheduling in construction agreements and contracts?
Well, you can schedule the other subs on the jobs, like the franchise people and wall people and landscape people, where they all have a schedule when they think they can be there to fit their part of the work in.
And the contract in 2.2 provides, it has references an estimated progress schedule. Looking at Exhibit 85, would you consider that to be an estimated progress schedule?
That's the same sheet. No, that was just our rough schedule. We thought we try to be at those numbers if everything worked perfect, but we didn't take consideration any of the other subs involved either.
Okay.
I'm sorry, Mr. Can you repeat that one more time for me? I'm so sorry.
Yes, those are our rough dates. We thought we could do the job, but it doesn't include any of the other subs involved, the franchise people and the landscape people, and to do their work before we complete our work. So there was different stages of the job had to be done along with us.
Let's go to Exhibit number 1. Okay, and on the third page of Exhibit 1, go one more page, fourth, I guess. Okay. And this is from the affidavit for lien. You see amounts due. You see that?
Yes, sir.
Okay, and it has draw number 11, phase 1 for $77,470.90.
Yes, sir.
Then the next page of the exhibit, if you could look at. And is that then the application for payment number 11?
It is.
And let's go to 2 more pages down. No, one more. No, other way. Thank you. Okay, and you see down near the bottom of a CO number 4. I'll give you the hard copy out. Okay, it's not that way in the book, so.
Number 4.
Yes, on the second page of the payment app, on the left side, there's a CO number 4. Do you see that?
Yes.
Okay. And what does CO number 4 refer to?
Change order number 4.
Okay. And what does it state as to one of the portions of change order number 4? You ever blow that up a little bit?
6 inch,
Yeah.
6 inch, 3,500 PSI concrete.
Okay, so. Okay, and then is there an amount that is charged for that concrete?
Or it's it.
Well, let me just go. That appears to be the same line.
14,430.
Okay. What does that relate to, if you know? Okay, so that'd be a Travis question? Okay, below, the next line below that states remove on-site dirt. Do you see that?
I did.
Okay, and we go over and there's an amount for that.
Right. 37,500.
Okay, can you say it louder so I can hear it?
37,500.
Okay, do you know what that charge relates to?
That's for the dirt they removed off site.
Okay, can you provide a little bit more background on that dirt removal, how that dirt got there?
The job itself was actually, when we started the job, it was set up and we had to change all the grades. So Monk, the engineer, and we had an actual dirt testing, dirt calculating facility do the dirt takeoffs for us. And the fact is, this particular dirt probably has a 3 to 5 PBR, which means it swells when it gets wet. So this dirt, the whole job was done under the wet conditions. So the dirt actually swelled. Most people don't believe that, but it actually swells. So this is much excess dirt had to be hauled off this phase and got rid of. And our contract doesn't call for any haul off, everything's left on place.
What work was being done with the work that resulted in extra work? Was it a leveling or what was being
Actually
done?
finished the finished pads out, to finish all the finished pads, all the parkways, to finish grades as the plans call for.
Okay. And at the conclusion then of that dirt work, there was extra work. Extra dirt.
Extra dirt had to be removed off site and they put it on adjacent property.
Okay. And then that's something that THB charged to move the dirt off of the phase 1 property to phase 2.
Yes, sir.
Okay, you can go back to the 3rd page of same exhibit. Okay, the next number is draw 12, phase 1, retainage for an amount of $184,674.84. We've heard some about retainage, but if you just briefly identify what the retainage is that related to that particular request.
Retainage typically is 10% of our contract we've done to hold it as a holdback from your job till it's complete. That particular draw is going to be phase, is going to be retainage, draw number 12.
Okay, you can go down to app number 12. It's about 3 pages down. Go down just a little bit. Okay, so on we see the amount, the same amount there. Is that then billing for retainage?
It's going for retainage.
Okay.
And yeah, no. Change order work. That's the total bill to job to date.
Okay, so line 3 shows current contract price.
Including retainage.
Okay, so if that's, and then the 10% of that is on line 8 to do this application for payment.
Absolutely.
Okay.
No, yeah, that's a whole payment, 184.
Right.
Yeah.
Okay, let's go up to the 3rd page again. Okay, it states invoice for tree removal penalty improperly deducted from draw number 10. Then if you can go to about the 6th page, there's an invoice. Okay, and is that the invoice then sent to Canterbury?
Yes.
And what was your involvement in the tree removal?
We were actually called when the city put a stop order on the job. We went to the city and tried to talk to them, me, Bart, and everybody, and the city would never come up with a real number. My insurance company, I notified them they would cover this claim, but they went to the city and the city wouldn't deal with them. And then Bart took over to heat handle it, and then we never did see anything else back out what the final,
Okay.
to date, I haven't seen the finals.
Okay, the page we're looking at is a bill for references deducted from draw 10 for $45,139.57. The previous testimony has been that there was a deduction from the amount paid on a prior pay app. My question to you, have you seen anything that actually has that amount from the city or otherwise, the amount of $45,139.57?
No.
And have you asked Mr. Reader as to any documentation on that issue?
I haven't, so Travis, we just want to see how the city actually calculated it. They got his bill, or maybe we get it funded from the insurance company.
Was there some work that was done on phase 2? by THB?
Yes, they were.
And what type of work was done on phase 2 by THB?
It was in our original contract to do all the dirt work. Because the dirt was a real problem, make it balance on this side. Did the dirt work. All of my suppliers had a real problem with the phase lines out there. They were kind of faint where they went. So the people were bad about shipping me all the material. So our people that furnished the sewer pipe, the sanitary sewer pipe and the manholes shipped us both phases. When I caught that, I went to Bart and his dad and said, look, you know, we send these manholes back, going to cost $10,000 they've already made. They said, we didn't, you know, we didn't catch the submittals and they had already made them. So we'll just put them in and pay me half of it and then pay me the other half when we finish the job. You know, when phase 2 come back online. And that's what we did. We put all the sanitary sewer in. Also, there was a section of storm sewer that had to go in. We had some issues with the storm sewer when some changes and plan changes after we went to work. And we had to lay some of phase 2 storm sewer to make phase 1 storm sewer work. So they did away with one of the lines. And we got a little storm sewer, a little sanitary sewer in phase 2 built all already.
And was that work then agreed to by Mr. Reader?
It was.
And has all of that work been paid for phase 2?
Yes.
There's been some discussions and statements today that you have heard regarding various delays in THB's work on the project. What type of things have delayed THB's work on the project?
For the first 4 or 5 months, it rained almost every day out there. If it rained anywhere, it rained on Bart's shop. We met out there on the job site. We even tried to bring a mixer in to mix the dirt in, but the black, scummy dirt, it just was not going to dry up. For every rain day, we'd have 3 or 4 days where it dried up enough we could go to work. We worked a lot of days we shouldn't have worked. That ended up costing us money at the end to try to push the job on. But that was one of the biggest concerns. And then we had some engineering concerns.
Okay, let's talk about what are the engineering concerns?
We had some storm sewer concerns in this manhole that we talked about had to be redesigned. And for some reason, the city of Raleigh and the engineer had a heck of a time ever making that decision how to make the manhole work. And that was all part of the changing from one storm sewer line, from 2 storm sewer lines to 1 storm sewer line. So that took continuous amount of time to get that redesigned for us. And the city wouldn't let us work out there. We got that done. We had everything done we could do besides that box. We had to finish the storm sewer.
And was that any fault of THB in the work that had to be done?
No, it wasn't.
Okay. I've seen a reference to a junction box issue. What is that?
That's what I'm talking about.
Okay. There's been reference to franchise work. What is franchise work?
Franchise work when they come in and they put your electricity to your house, your gas to your house, telephone to your house. They call that dry utilities in our business. Originally, we were going to try to do the franchise on the job. We could never get our gas license. So we ended up not doing anything on the job, but it kind of got to a point when we got ready, we couldn't find anybody to come put the crossings in. So the job sat there for some amount of time. And then at that point, they decided they couldn't get there at all. And we went back and the city wouldn't let us just leave out patches. So we'd take all the steel out, come back and go back and then pave it. And then they come and board it after that. So that cost quite a bit of time to get to that point.
Was there a power pole issue that caused any delays?
There's a power pole on Cheesy Road that was there. We probably noticed it 5 or 6 weeks into the job and trying to get it moved. It finally got moved probably within the last 30 days we was on the job. Because that was the last piece of concrete we poured, I think. Because we were waiting on getting the telephone, and the city wouldn't let us just block out around it. They made us wait till the pole was moved.
And was that, you consider that any fault of THB for that delay caused by the power pole?
No, sir.
Was there a delay caused by the SWPP?
There was a small delay on that, which we had no control over that. We just put the initial silk fence in. The owner took care of all the erosion control stuff and all of the maintenance and everything else to go with it.
One question, just briefly, going back to the issue with the tree removal. Who do you understand has the responsibility to rope off or cordon off the trees that are to not be cut?
Normally, the owner will hire somebody to come out and put a fence around the trees they're going to save. This particular job didn't get done that way. There's a lot of the reason the trees got cleared. The silk fence was behind them, and the hands, it was really muddy. And but in lieu of that, another thing I've been wanting to get with the city about, after going over the profiles and the grading plans, most all the trees they said that they were going to keep, they couldn't have kept because they had fill on them or cut on. The trees wasn't going to last, and it wasn't going to live anyway.
And there's been testimony that the contractor was terminated in the June 2020 time period. Did you have occasion to see what the work looked like at that time?
I did. I would say Travis was there more than I. I made the job probably once a week. The city we were appointed for a punch list. The city wouldn't give us a punch list, the landscape was done, and the landscape was the owner's responsibility. In fact, we were at a process of TV and the sewer lines. At the same time, the owner hired somebody to come do it. They both showed up the same day to do it. So at that time, it was hard to get anybody to do any kind of testing at all. Everybody was so busy, and the lack of equipment and people in town to do it. So it was hard to get anybody scheduled to come do it.
But at the time then of the contract termination, what types of things did you observe still needed to be completed or punched?
We were down to the punch list island. It was miscellaneous stuff to do. My opinion, what was good, and what the city's opinion, what was good. So it was down, it was finished. Just waiting for the city to punch it out for us.
Okay, and I believe what you've stated that at that point, there had not been landscaping done, is that
Right.
right?
They had the landscaping done before they give us our punch list.
Okay, and THB wasn't the landscaper on the property.
Was not.
We could pull up 134. Now, Sean, it's the one you added. I'm not sure it's been added to this list. The mitigation expense and damages one. Here we go.
All right, that's 138. Do you want me to bring it up? for you?
I think we got it. We got
Okay.
it. So, okay, we're looking at exhibit 138, and you've heard the testimony of Mr. Reader relating to, I believe, additional expenses and completion type work. There's a line of final grading phase work for $16,575.25. When at the time you observed the property in the early June of 2020, were you aware of additional grading that was going to be required on the property?
I was not.
Okay. And does that number surprise you in its amount?
It does.
Why so?
Well, they actually cut all the lots to get all the dirt they had to move anyway. So I'm surprised that they come up with that kind of number to move, whatever they did move, I have no idea.
There's a entry for corrective paving work for $12,812 from your observation at the property in June of 2020. Were you aware of correcting paving work necessary?
I was not.
There's an entry for raised water meter taps of $3,300 at the early June 2020. Were you aware of the need to raise water meter taps?
I was not.
Were you aware at that time of any City of Rowlett required corrective work in June of 2020 on the property?
I was not.
I'll pass the witness.
Eddie Cross,
Yes, Your Honor. Thank you. Mr. Boney, I took your deposition before, correct?
Do what, sir?
I took your deposition before, right?
Yes, sir.
Yeah, it's nice to see you again. I'm going to start with the contract that we were looking at. This is Exhibit 3. You've seen this contract before, correct?
Yes, sir.
And you understand that there is a provision in this contract that requires the contractor to provide a progress schedule to the owner, correct?
If the owner requests it, yes. Normally done before the contract.
Well, this is actually specifically says in the contract, it's done after instructions from the owner to commence. So that would presuppose that there's a contract entered and the owner has said, go ahead and start your work, right?
Right.
Okay. And you did start your work after you entered into this contract.
Yes.
And do you recall giving them a progress schedule to the owner after you entered into the contract?
I assume a project, yes. Yeah, estimated days, yes.
And the only time you sent them a schedule for work that we're aware of in this case that THB produced or that has been shown in this litigation is the email that you sent in January 2019, correct?
That's correct.
And so if we look at Exhibit 85, this is in specific response to Mr. Reader. Let me show you, make sure you're seeing it. This is in specific response to Mr. Reader's question to you, asking for requested information that you've been talking about for weeks, right?
Yeah, I've been talking to Travis mostly, yeah. Yes.
And your response is to provide a schedule that shows a final out of April 15th, right?
Yes, sir.
Now, you didn't use the words completion date, did you?
Did not.
But you did use the words final out, right?
Yes.
And you didn't use the word estimate or rough approximation, right?
Did not.
In fact, you didn't qualify this schedule in any way whatsoever in this email, did you?
It was just a rough guess for us. You know, it wasn't, you know, like I say, it was just, it wasn't about what I thought the days would be. And I give them about what I thought they would be.
Okay. And at the time you gave him those numbers, you intended to comply with those numbers for those dates.
Except the other subs, you know, we didn't break it down. It was never meant to be a supplement anything. If that would have been that way, we'd have broke all the subs out and timelines out and the delays and we didn't have any of those to go with. So he just wanted how long it take us to do it. And that's what it should take for our work days, but to do it. So.
Yeah. One of the things you said in your direct examination was you didn't put a completion date in here because that would be difficult with all the different subcontractors and getting their schedules together. Is that right? Did I understand that correctly?
They're not my subs.
That's right. You don't have any subcontractors, right?
I don't have any subs, that's right.
So there were no subcontractors on this deal. It was THB doing the work in hiring suppliers to provide supplies?
Franchise people, what I should have said. Because we're shut down waiting on people to do scheduled work. I have to stop till they get the crossings in for the electric gas. So that gets done, I can't proceed on. They gotta get them up, put in density. This job took a long time to get that done. There's a big gap in our work.
When did that happen?
I don't remember exactly the days.
Was it before April 15th that started?
You know, I really don't know.
Yeah. But the bottom line is as of January 2019, in response to repeated questions from Mr. Reader for a schedule, you gave him this schedule, and this is the only schedule you ever gave, Mr. Reader. Right?
Yes.
And it's not a rough approximation, at least in this email. It is the schedule is below. That's how you defined it.
No.
I mean, that's what it says, right? Schedule is below.
I said schedule is below.
And in fact, it's historical in certain respects. The sanitary sewer, according to your schedule, has already been done.
Right.
Right. So this is your schedule for the construction progress that you're telling Mr. Reader we're going to have a final out on April 15th. It's not an estimate.
It is an estimate. Go ahead.
You think it's fair that you provided a contract to Mr. Reader that had a delay provision with a liquidated damages provision, and that THB can now escape the delay costs by simply claiming there was never a completion date?
We do, like I said before, we don't do hardly any jobs with hard date finishes.
So this is a typical practice. You give contracts with a delay provision that has liquidated damages, but you don't provide a completion date so that you don't have to have a delay damage.
This particular contract does, yes.
Okay. And it also has a time is of the essence clause, right?
It does.
So the time is of the essence.
Too. We didn't go out there not to finish it as fast as we could. We didn't go out just not to finish it.
The only party in this case that didn't experience delays is THB, because they were paid every time they got an application presented, right?
Do what now? Try it one more time.
The only party in this case that didn't suffer from delays was THB, because THB was paid promptly after every pay application, right?
It wasn't promptly paid, no.
You sat through Mr. Reader's direct examination, right?
I did.
You disagree with each one of those pay applications where we showed that they were paid before the next one was submitted?
Yeah, we were always late. We never got paid on 20 days after we billed on the 25th. Actually, I think it was paid 10 days afterwards anyway, but we never got paid till we were doing the next. We're doing estimates, hadn't been paid for the last estimate.
That's not true, is it, Mr. Boney?
Yes, it is.
In fact, when I took your deposition, didn't you say you didn't know whether or not you had a payment delay on any one application period?
So I couldn't tell you exact which pay estimate paid what day, but yes, they were slow pay.
Okay. And you know that every time you submitted a pay application, you had to certify that you had been paid already and those funds had been used or would be used to pay your suppliers, right?
Yes.
And if you were submitting pay applications every 30 days, that means by definition, you were receiving payments timely.
No.
Right?
No.
It doesn't. You have any evidence at all that THB was not paid timely?
Yes.
What's your evidence? What's your explanation?
We didn't get paid by the 10th of any month. Bill the 25th, get paid by the 10th. I think where our contract is set up.
The contract requires payment within 20 days of a properly presented pay application, right?
Pay on the 15th then.
And so if you presented a pay application on the 25th, you would typically be expected to be paid the 15th of the following month.
That's true.
Now, if your pay application had an error in it and it had to be corrected, which happened on occasion, right?
Almost every, it changed a foot. Barricade be 98 feet, it changed to 98 feet. Yeah, he changed every one of them.
Yeah. Or alternatively, another way to look at that is THB created an error when they gave them a pay application that needed to be corrected. And then at the time a proper pay application was submitted, then they were paid.
Okay.
You don't disagree with me that THB had problems paying its suppliers during the course of this work?
We had some time issues paying suppliers. We did. They've all been paid, but yeah,
They've been paid now, but after several of them put liens on the property?
I think two actually got liens. That normally doesn't happen, but yes.
It normally doesn't happen. In fact, it doesn't happen because a generally prudent contractor would pay their suppliers from the funds as they get them, right?
We try to do that too.
And in this case, at least two of them didn't get paid by THB.
That's true.
And that's a violation of the certifications on your pay applications, right?
Okay.
Isn't it? You agree with me, right?
Yes.
Okay, let's talk about your lien. Which is Exhibit 1. Let's see if I have this here. This was filed in July of 2020 after the termination, correct?
Yes.
And this page, I think it's 4 of this document, is the line items that you contend are owed to you and improperly withheld.
Yes, true.
And the first one is the 77,000 for phase 1. That number right there is incorrect, isn't it?
I think so.
And aren't you withdrawing your claim for approximately $21,000 in maintenance bonds that are included on that?
Yes, we are withdrawing that because we sent the bonds back. Yeah,
You never
we had
paid for the
sent back.
bonds, did you?
Do I know?
You never paid for the bonds, did you?
We paid for them and sent them back because, they were
You-
probably going to do something else with them. So
Do
we
you
kept
have
them,
any,
we sent them back to them.
do you have any evidence? Did you produce any evidence that THB purchased or acquired a maintenance bond?
I do.
And was it produced in this case?
I think it was asked for produce in this case.
I'm sure it was. Was it produced in this case?
No, I don't know.
You asked to be paid $21,000 for a maintenance bond that was never procured in draw 11. Isn't that right?
Okay.
And so now you're withdrawing it, but you still have a lien amount that's out there in the public records that's overstated at least by $20,000. You agree with that?
I do, but yes.
Okay. And now the other amounts for the phase 1 draw application include approximately $37,500 for hauling off dirt.
Yes.
Now that number, you didn't provide any documentation or corroboration for the amount of dirt that was hauled off, right?
They did.
Other than the pay application?
No, they sent them on load counts where they hauled off.
You sent who, what counts?
Load counts, yeah, how many truckloads they hauled off.
You provided Canterbury Cove load counts?
Yes,
When?
during the billing.
Okay. They're not on your exhibit list. You didn't produce them in this litigation, right?
Do what now? Sorry.
They're not offered as defense exhibits in this case, are they?
And send the bill, the backup to the bill, I would assume they had truck counts with it.
You would assume that, but you haven't seen it?
Yes.
Did you see it?
I haven't personally seen it today, no.
Did you personally prepare them?
I didn't do it, Travis did the bill.
Okay. How do you know that there was exactly 7,500 cubic yards?
By the load counts they hauled off, that's why they keep up with them.
Or alternatively, you just made up the number?
No, they do it by load count, that's the way they can keep up with it. Every truck gets loaded the same, and how many yards go in every truck.
How many cubic yards was the excavation in the original phase 1 work?
I don't remember.
Was it 49,500?
If that's what you said, I don't have that in front of me.
Do you know if the 7,500 was included in the 49,500 that was already charged as part of the phase 1 excavation work?
Most of this is gonna be swale dirt, where it's swelled out there, the actual dirt swells. And actually the utility spoils or franchise spoils, everybody's spoils is what gets told out of the job at the end.
And again, you don't have any documentation or analysis by a third-party engineer that shows that there was swelling of the dirt that amounted to 7,500 cubic yards, do you?
I do not.
And you don't know whether or not it's included in the original 49,500 cubic yards in the original bid.
Well, the original bid, we cut that dirt. Yeah, we cut all that dirt to grade. Then after that, after that, the dirt that's there now, what got calculated or accumulated over the franchise people to swell the dirt. Whoever, just the extra dirt everybody it ends up with it haul off.
And you charged a higher amount in the phase 1, draw 11 phase 1 amount in the lien than you did with the original contract. Why would you do that?
I did watch that one more time.
You charged a higher amount when you filed your lien for the excavation work than you did for the original work. Why would you do that?
I filed for a higher amount on the excavation.
The phase 1 draw 11, you charged $5 a unit, $5 a cubic yard. Right? You see where my cursor is?
I think that's just a change order. I think it didn't.
That's where you charge the 37,500 that we're talking about.
Yes. That'd be right, because it's trucks instead of scrapers. Yeah, whole different kind of dirt. It'd be a different price, yes.
It's a different kind of dirt. So you're moving dirt to originally do the excavation.
With loaders and blades and dump trucks instead of scrapers and dozers, yes.
So it costs $1.75 more to haul dirt away than it does to actually shape and form the actual residential subdivision?
It does.
And what's your basis for that?
Just costs that much more equipment time to handle the dirt.
How long did it take to remove 7,500 yards of dirt versus shaping the entire subdivision in phase 1?
Days.
It took a lot less time, didn't it?
A lot less time on what?
To move this dirt than it did to actually do the original excavation.
No. It's a whole lot more expensive dirt to move. Finish up dirt, final dirt, finishing the job up.
You also included in there in your lien request $14,000 for 6,500 PSI concrete.
Yes.
Do you know what that charge was for?
I do not, top of my head, I do not.
And do you have an understanding as to whether or not that had already been agreed to be removed because it wasn't a proper charge in the last draw application before this final one?
I really don't know about that.
No, if it's true that the parties had agreed to remove it and you added it here, that would be another reason why this is an overstated amount, isn't it?
I have no idea what the item is. Travis made those up to finish the job up.
You included also here an invoice for the tree removal penalty. You re-invoiced it. What is the contractual basis for THB to re-invoice a tree penalty?
I don't think contractually he took it out of my money, actually.
You agree with me that the owner has the right to remove or withhold amounts that are due to their damages or other violations of the contract, right?
I'm going to disagree with that exactly.
You do?
Yes.
You disagree with paragraph 3.3 of Exhibit 3, your contract?
Yes.
What part of it do you think does not justify THB from having its payment withheld?
Well, those payments he withheld, there's no backup to them at all. Just that's what he come up with. And I don't think you can back charge an insurance type deal like that too. Because we may still get the insurance pay for. I don't know to take the trees.
You closed the claim, right?
They closed the claim, but the city wouldn't talk to them.
So there's not a pending insurance claim right now.
Yes and no. I've called them and put them on notice. I may be calling them out there to see what we get out of the insurance.
You may be.
Yes, I put them on notice. I did.
Okay. But you agree with me that paragraph 3.3 here says that an owner may withhold for damage caused or for the failure of the contractor to perform under the contract.
That's what it says.
Okay. And there's not a corresponding provision where a contractor gets to re-invoice for a charge they disagree with. Is there?
No.
And in fact, when it was withheld from pay application 10, THB accepted that payment and didn't object at the time.
THB what?
Accepted the payment with respect to draw number 10.
Yeah, but I'm sorry, maybe I understand what you said.
Yeah,
We
so
expect
let
to
me,
be paid
I
the
can do it.
45,000?
I can be more clear. So Canterbury Cove withheld $45,000 roughly for the tree penalty in pay application 10, right?
Yes.
And they paid the balance, the remaining balance of pay application number 10 to THB.
Yes.
And THB accepted the balance of pay application 10.
For the estimate, yes, we did.
And you did not send them a letter, email, or any kind of written objection at the time that you disagreed with the tree penalty being withheld.
I think they verbally discussed that when Travis picked his check up.
Yeah, and I think Mr. Reeder testified that Travis accepted the payment.
Yes.
Oops. The phase two retainage amounts, you agree with me that those amounts aren't due yet, right?
Technically, without having them tested, no.
Yeah, I mean, phase two, you only get paid when the city and the owner have approved and completed it. And in this case, they can't have approved it because they haven't done testing on those sanitary sewers, right?
That's exactly true.
So at some point in the future, when phase two is completed and approved, these amounts may be due subject to whatever defects the testing might reveal. You agree with that?
Somewhat, yes.
All right. But as of July 2020, there's no question in your mind these amounts are not yet due.
That's a thin line, actually. I'd say they are due to close the job out, far as we are concerned. Us and the readers, we've cleaned the lines up. Yes, I say it is due.
Okay. But you understand that the contract has specific conditions for final payment.
Yes.
And those specific conditions aren't satisfied.
Okay.
You agree?
Well, not particularly, but okay. I mean, that's, we could argue about the testing not being done.
All right. And
the pipe was all inspected. The inspectors inspected the whole job. They inspected them all the densities. The only thing we haven't had done is run a TV camera down both of these.
It hasn't been air pressure tested or TV camera, right?
On the sanitary, is air pressure, the manhole, that's right.
Right. Okay. Now on your delays, you contend today that there's no completion date, right?
That's right.
So your contention today in this litigation, after the lawsuit was filed, that there was not a completion date by which a delay could be calculated. Correct?
That's right.
But during the course of the relationship, THB believed that there were delays that needed to be justified, right?
Not particularly. We keep up with days on every job we do. How much it rains, how much it doesn't rain. So typically, that's just the way we do it, to try to explain where we're at, I guess. But because we're all trying to finish our jobs as fast as we can.
But you knew that Canterbury Cove was complaining about the project being massively delayed, and THB took efforts at the end of the relationship to try to justify its delay, right?
We tried to justify the delays every day. We tried to work every day we could.
The only time you actually took action and provided any kind of written documentation to justify your delay was when you were threatened with termination and ultimately terminated. Isn't that right?
I don't think so.
The only written documentation that you provided to Canterbury Cove is the schedule of the weather days and the summary of your delay excuses that happened right at the end of the relationship. Isn't that right?
I don't know that the exact date. We sent him something though.
Okay, I'm going to show you what's marked as plaintiff's exhibit 60. This is a document that you guys provided to Canterbury Cove during the course of the relationship. Isn't that right?
What's the date on it?
I don't know that it has a date on it.
Oh, well, that make a big difference. Okay, that is their work, yes.
Do you disagree that this is something that was provided by THB?
No, that's some of our work, yes.
Okay, and it provides a date here for available work days from the October period to April of 2020, right?
That's right.
So presumably this is after April 2020,
Yes.
unless you're a time
Or I'd
traveler.
say it is. I'd say it's April the 20th. If I had to guess the way they did it. Yes.
All right, and it says here there's one of the delay excuses that THB provides now is that there was a problem with the junction box that caused, as according to THB, approximately 19 days of delay. Do you see that?
It is.
And the delay started from February 11th, 2019 to March 10th, 2019, right? Is that right?
I don't know when the rain started, to be honest. That's what the delay on the boxes are, yes.
Okay. And the way I heard you testify about it in your direct examination was that it took the city a long time to approve the junction box.
It did.
So am I to understand it that your understanding for what the delay was that from February 11th to March 10th, 2019, that for those 19 days, the city had not approved the junction box?
That's true.
Now, plaintiff's exhibit 87 is an email dated February 13th, 2019 from Bart to you, Mike Boney and Travis Boney. You see that?
That's it.
And it forwards to you an email from the engineer at Monk Consulting, Jennifer Malone, that says, here's the official city approval of the junction box. You see that?
Okay.
And then the email below is from the city that says, we're good with the junction box. We typically want exit velocities around 68. Your original drawing met that condition. You see that?
Okay.
So literally the day after you say the delay started because of the city told Canterbury Cove and you that the junction box was approved.
No.
You disagree with that email?
Yeah.
Okay. How did the junction box delay impact the critical path to completion of this project?
We were down to finishing the storm sewer. We had to finish the storm sewer before we go any further. Before we could pave it, we had to finish all the storm sewer before we could pave.
Okay.
The junction box was all part of the storm sewer.
And you couldn't,
and it wasn't approved that day. I don't know if the dates are wrong on their range dates or the dates are wrong on the email. The city cut it back, took it back and redid it. I don't know. Because we waited at least 3 or 4 weeks to get the junction box approved.
well, I agree. You probably waited 3 or 4 weeks, but exhibit 87 says that it was approved on the 12th.
Well,
and it was forwarded to you on the 13th.
We damn sure the delays do it.
Okay. The junction box is on the outfall over by the lake on the western side of the property, right?
Junction box where the pipe all comes together. Yes, sir. Go out to the lake.
So it's on the western side of the property.
Yes.
Is there anything that would prevent you from working on the eastern side of the property while you waited on the junction box?
We were at the point to pave it, and you couldn't pave it till they had all the storm sewer accepted, and the city wouldn't let us proceed till the manhole was finished.
Okay, but you got no evidence of that. It's just you saying that now.
I would say that's probably true.
All right. The tree removal here, you think that is Canterbury's fault because they did not protect the trees, correct?
Yes.
And you said in direct that the reason you think it's their fault is because typically a contractor or an owner will hire someone to protect the trees.
Put the fence around them, yes.
And yet your master contract specifically requires you as the contractor to protect the trees. So didn't they hire you? to do that?
They could have, but we had no fences and trees to do, and no tree protection set up in the contract.
The contract specifically calls for tree protection, doesn't it?
It says, I think it doesn't say just to try to save the trees, don't take out trees. I don't know how it exactly reads exactly. It doesn't say tree protection, I don't think, period.
Paragraph 18 of the contract, 29.1.18, trees, contractor shall protect all trees unless authorized for removal by owner. What does that mean to you?
We should stay away from the trees.
And instead, after being handed the tree preservation plan in person by Mr. Reader, and after having it emailed to you the week before, you had the excavator just bulldoze the trees to the property line on the west.
Not exactly, but okay. That happened that way. Trees got removed.
That's right. And you don't disagree that the trees were flagged with a green ribbon that shows which trees need to be protected, right?
I personally don't know either way. No.
Okay. You talked a little bit at the end of your direct examination about the additional expenses that you were not aware of the need for additional expenses that were incurred by Canterbury Cove, right? Like for instance, the $16,000 in additional.
Oh,
break-in.
yes.
And you testified you were not aware that those charges were going to be needed, right?
Yes.
You were not privy to those conversations after your termination, right? Because you've been terminated from the job.
That's true.
So the fact that you're not aware of them doesn't mean that those weren't necessary corrections to the work or completions to the work, does it?
Well, that would be true, but the explanation they've got on the worksheets we got here from the billing doesn't really say much about how they got to that number. How many yards they moved? What they do with the dirt? I mean, lots they bench. Because I think all the lots were benched when we left.
You think that, you know?
Do I personally guarantee I went out and shot every lot? No. But I think all the lots were benched.
Oh, 1 second. I think I'm almost done, Mr. Boney.
You what, sir?
I said, just give me 1 second. I think I'm almost done. Okay, I'll pass the witness.
Just a few follow-up questions. You were asked about Exhibit 85, which was your email to Bart, and you referred to that, I believe, as an estimate or guesstimate. We could pull up exhibit number 3 and specifically provision 2.2.
I get control of the share screen.
Yeah, Sean, can you take that one down so we can get?
Oh, I'm sorry. Yeah, I was writing notes. Apologize.
Okay, go to 2.2. Okay, now 2.2, contractor shall prepare and submit after instructions from owner to commence an estimated progress schedule for constructing the improvements to be approved by the construction manager and owner. Looking back at Exhibit 85, would you characterize that as an estimated progress schedule or not?
That's what we estimated, yes.
Okay. And if you were aware that THB may be subject to a $750 a day amount for passing the completion date, then how would you go about estimating what a completion date would be?
We'd actually had working days set up on the job. Wherever there were a little shortage, we'd add to our change orders, add days, add every day that it rained, we'd split a work out. We're not going to work today, not going to work today. And fill the work days where you have to be continuous work on the main item for more than 6 hours a day.
Well, would you be very conservative with?
Very conservative dates. You know, I said the dates would have been way out there, and every day we did miss, we'd have documented it and not been out there the wet days at all.
And how long would a job like this typically take?
You know, in good weather, the shops, you ought to be able to do this job in about 8 months. In good weather today, eight months back then, probably.
Okay, but if you were putting yourself as being subject, or the company is being subject to a $750 a day charge for not meeting the complete date, would you put a completion date of 8 months on a job like this?
No, we'd probably put 12. And the few jobs we do with liquidated damages, you always put bonus days with them.
And what's a bonus day?
I'm gonna say you're gonna do it in 12 months, you do it by 10, you pick up the 2 months of bonus time because you're gambling on the delinquent time.
And you were asked about some correspondence attempting to document delays. Again, is that something you would do when there's a completion date, there's not a completion date, or in any type of contract? The
Mr. Hayes, I think you guys have kind of beat this to
Okay,
death.
sure.
I get
Yeah.
it.
Okay. I've got no further questions, Judge.
Nothing further, Your Honor.
Okay, call your next witness.
Okay, we're going to call Travis Boney, he's got to link in. He's in Lubbock.
Okay.
We take just a short break to get him online. He's got the link, but we're calling him right now saying, get on, so.
Okay, they're ready for you. Time up.
Here he is.
Hello?
Mr. Boney, you need to turn on your camera.
Are you there?
Yes, please raise your right hand. Mr. Boney, you need to raise your right hand. Do
It's
you
raised.
swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, sir. I
All
do.
right, let's proceed.
Sure. Can you state your name for the record?
Travis Michael Boney,
What's your position with THB Construction?
sole member.
And just very briefly, what is your experience in the construction business?
I've been in this business my whole life from early age. Doing dirt work, water and sewer utilities, concrete paving, making material, trucking business.
And I'm going to refer to the Canterbury Cove project, phase 1 and phase 2. You know what I'm referring to, correct?
Yes, sir.
Okay. And were you the individual on behalf of THB that was negotiating the contract for phase 1?
Yes, sir.
And who did you deal with as to those negotiations for the contract for phase one?
With Bart Reeder and his dad.
Was there, in the discussions as to prior to the agreement, were there any discussions regarding a specific completion date?
No, sir.
Okay. And you've reviewed the contract for phase one. Is your understanding that there is a specific completion date or not a completion date?
There was never a completion date on the contract.
Okay. Are you aware the contract refers to a project supplement? Are you aware of any written project supplement?
We never did provide a written supplement for them. I think there is in the contract,
Okay.
but it never was provided.
Okay, let's go to, we're going to pull up a document marked today as Exhibit 85. And this was talked about today. This is, the top part is an email from your dad, Mike, to Bart, where it talks about a schedule below. Did you ever understand that to be a completion date as per the contract?
No, sir.
Okay. And what was your understanding of what Mike had provided in that email in front of you?
It was our best guess scenario. If everything worked right, you know, we could be possibly finished on those days.
Okay. And is it common in your experience for an estimated progress schedule to be provided as to work that is up and coming?
What's your question again, Scott?
Okay. From your experience in the construction industry, is it common that there are estimated progress reports that are provided by contractors to the owner or subs to contractors?
Yeah, I mean, it's standard to have a some kind of a schedule when you think it'll be finished, but nothing's ever, you know, in stone or say it's a hard date of this day you'll be done. Kind of a guesstimation.
Okay. Okay, let's pull up exhibit number 1. And this is the affidavit claiming lien that you've signed on the 3rd page. Is that correct?
If you scroll up there, yes, I signed that.
Okay. And that was done at a point in time after THB had been terminated from the job. Is that your recollection?
I believe so, yes, sir.
Okay. Let's go to the next page. And looking at the page with the amounts claimed to be due, I want to go through briefly these. The first is draw 11, phase 1. And on the 3rd page of draw number 11, there is an entry for remove excess dirt for $37,500. Do you recollect that charge?
Yes, sir.
Okay. And are you familiar with what was done for that work for the dirt removal?
Yes, sir.
Okay. And were you, of THB, between you and Mike Boney, who was the primary one on site and in charge for THB?
during the dirt work phase of the change order.
Yes.
That was myself.
Okay. And how, just describe very briefly the dirt work that was done that resulted in this charge for $37,500.
Well, the job had too much dirt on it, and there was nowhere to put it, so it had to leave the job. Bart and I talked to the landowner beside him, and he said he would take the dirt for free. So that was Bart and I's cheapest option to get rid of the dirt. And so I had my own dump trucks brought in. We loaded the dirt in the dump trucks and dropped the dirt off on the neighbor's property and spread it out smooth.
And was the dirt removal necessary for the completion of phase 1?
Yes.
And how'd you come up with the $37,500 charge?
It was based on how many hours it took to do that job and how many loads of dirt we moved.
So in preparing that document, you had knowledge of those figures of dirt moved, trucks needed, and time?
Yes, sir.
Okay. An additional charge there is for concrete for $14,450. Are you familiar with that charge?
Yes, that was the Pentagon Junction box that the city made us put in.
Okay, and can you just describe a little bit more about that transaction and the cause of that work and charge?
Yes, the engineer designed a stormwater system that was too small to handle the volume of water coming down that street. So the city wanted to upsize that line. When you upsize that line, you have to have a bigger junction box to handle the volume of water. And for some reason, the city wanted a octagon shaped box. Those are not very easy to build. And so therefore we charged them the increase in quantity for $14,000.
Okay. And then you're familiar as to how those charges came about?
Yes, sir.
In terms of the amount?
Yes, sir.
And was that work necessary for the completion of phase 1?
Yes.
And is that work that Canterbury Cove and Bart knew were being done?
Yes, sir.
Okay. There was also initially in the affidavit that was signed a claim for a maintenance bond of about $21,000. And you've not been present, but that today THB is not pursuing that particular amount in this claim, but just you can explain how that maintenance bond charge then arose and why it was included initially.
Yes, sir. The reason that was included on the bill is that we normally charge for that and collect the money, and they go buy the bond. Once we buy the bond, then we'll issue and then we'll give it to the city and also the owner.
Okay, so it's a typical charge that's made because then the owner is going to pay it for the bond, correct?
Correct.
And here was the bond actually then submitted to the city?
I don't believe we ever gave a bond to the city.
Okay. Also on your, go back up a few pages. There's an amount for retainage for $184,674.84. And we've talked a lot before you joined us today about retainage. But then that was the then amount of the retainage at that, the 10% retainage at that particular point that had not been paid. Is that correct?
Yes, sir.
Okay. And at the time of filing of this, there had been a termination of the contract by Canterbury Cove. Is that correct?
Yes, sir.
And was your understanding then, based upon that, that the retainage was due or would then become due?
Yes, sir.
The next category is invoice for tree removal penalty improperly deducted from draw number 10. And again, there's been testimony and discussion about that particular amount. Have you ever seen anything showing that Canterbury Cove has paid a tree removal penalty amount of $45,139.57?
I've never seen anything that Canterbury Cove ever paid out. I know they deducted that much money out of my draw. So I picked up the check. Bart said, nope, not paying that for you. Deduct it out of your money. I said, well, Bart, that's not right.
And so then that at the time that you got paid on that particular draw, that was already taken out. Is that accurate?
Yes, sir. That's correct.
And you did not agree with that takeout?
No, sir, not at all.
And did you believe that THB was owed that money and that it was an improper removal or takeout or holdback of money?
Yes, sir, 100%.
Okay. And is that why that claim then was asserted through an additional invoice?
Yes, sir.
Let's move now to just a couple entries on the phase 2. And there's been testimony today. I won't spend much time on it, but there was some work that was done on phase 2 by THB. Is that correct?
Yes, sir.
Okay. And that work, well, was that work agreed to by Canterbury Cove that would be done?
Yes, sir. Yes, sir.
And just briefly, why was that work done on phase 2?
Originally, the job was split up into 2 phases, phase 1 and phase 2. But for some reason, our utilities pipe supplier shipped us all the pipe for phase 1 and phase 2. And Mike talked to Bart and talked to the readers, said, hey, you know what, guys, the material's already on the job. We're here to lay in the pipe. It's everybody's best interest. Go ahead and lay it once it's here. It's deep, but nobody's going to bother it or mess it up or damage it. And they agreed, yes, let's go ahead and get that done.
Were there some amounts paid for work done on phase 2?
I'm not for sure, Scott.
Okay. And the attached to the lien affidavit was then a payout for phase 2, number 2, for an application for payment for $51,115.01.
I guess that's right. I have that paperwork in front of me.
Okay, we're
Trying to find it.
go up. Okay, we're going to show you. Let's go up to the first page to PHT. Okay, go. I guess it's. Yeah, okay. Okay, we have that now. It's just difficult to see on the screen. But then is that, let's go down, the payout then would show the type of work that was done on phase 2. Is that correct?
Yes.
Let's go down to the next. Go back to the other, go down, up, I'm sorry. Okay, yeah, it's, no, I'm trying to do this page right here.
Okay.
Yeah,
That's it.
sorry, it's sideways on our page. I'm just trying to let you see the description of some of the work then that was done to go into the charge.
There we go. There we go. It's going to be sanitary sewer and maybe some storm drain. I can't see a way you have it zoomed in, zoomed out. I can't see. But it's gonna be a sanitary sewer and maybe a storm drain in there as well.
Okay, but that you had prepared or part of the pay app and were familiar with the description of the work then that was done.
Yes.
And showing the amounts and charges for that work that's set out in this pay app for $51,000 and some change. Is that correct?
Yes. Yes.
And again, was it the understanding that that work on phase 2 would be paid for?
Yes, for sure.
Okay. And the $51,000 set out in the pay app 2 was not paid to THB.
That's correct.
And finally, on the calculation, go to this page right here. Pay app 3 is a retainage amount of $12,235. You see that?
Yes, sir.
Which is then 10% of the work that had been done on phase 2. At that point in time, when this was prepared, was the termination then on all the work that was being done at Canterbury Cove by THB, phase 1 and phase 2?
What was your question, Scott?
Okay, at the particular time of this, the time the lien affidavit was filed in July, was there any more work that THB was going to do on phase 1 or phase 2? We're now in July 2020.
No.
Okay. Okay. So did you consider then that amount to be owing as of that time because there'd been a termination by Canterbury?
Yes, that is correct.
And in signing and filing the lien affidavit, did you have any intent to defraud by what you put in there?
No.
Did you believe the amounts were owing in the lien affidavit?
Yes, sir.
At the time that in June 2020, at the time that THB was terminated from phase 1, were you aware of the condition of the work that had been done by THB on phase 1?
Yes, sir.
Okay. And at that point, can you just describe, what, if anything, still needed to be done that was within the scope of THB's contract?
We had to come back and re-TV the sanitary sewer system and possibly coat the manholes in phase 2.
Okay, but as to phase 1, was there any work that was still to be done other than just a punch list type item?
No, sir.
Okay. And in early June, did you meet on site with Bart Reeder as to the condition of the work that THB had done?
I don't recall what day or month or year it was, but we did meet with Mr. Reader several times on this project. One time we brought out, our Robert Kemp and Matt, who used to work for us, to see if we can resolve this, and ain't really get anywhere.
Okay, but my question, do you recall, regardless of what the date actually is on the calendar, that near the time of the termination, did you recall meeting with Bart on site as to what still may need to be done or not done on the project?
Yes. Yes.
And what do you recall from that particular meeting? In terms of any more work that was necessary to do?
I don't recall anything need to be done. He was concerned about the trees, and I was concerned about the money he's taking away from me. We kind of went around and around about that issue.
Okay, but as to scope of work still to be done, do you recall any discussions in what may be your final meeting on site with Bart Reader?
No, sir.
And just briefly, were there delays in THB's work caused by junction box issues? And if so, please describe.
Yes, sir. It took several weeks to get the junction box issue resolved, plans drawn up, city accepted, additional material brought to the job to be able to complete it. Yeah, there was substantial delays.
Okay. What about, did franchise work cause any delays in THB's work?
Yes, sir.
Can you describe, please?
Mainly waiting on them to finish bringing material in, getting the manpower out there to go finish the work.
Was there delays? Well, did power pole issues cause any delays?
Yes, sir. Mainly in the approach.
What does that mean?
There was a power pole in the intersection of the concrete approach coming off the main road into the subdivision, and it had to be removed.
Switching gears back for a minute to completion date. Was that an issue that was brought up by Canterbury throughout this, that, oh, there's a completion date in April and you've busted the completion date? Or were there?
Yes, they brought that up. Yes, sir.
Okay. I'll pass a witness.
Hey, Mr. Boney, how are you doing?
Doing well, and yourself?
Doing okay. I'll try to be brief here for you. You understand that the contract that was entered into in this relationship between THB and Canterbury Cove had a time is of the essence clause?
I don't have the contract in front of me, so I'm not for sure.
Do you have any reason to disagree? I'll bring it up if you want. Let's bring it up. Hold on one second. Exhibit 3 is the contract, and I will show you that. You see here in paragraph 9.6 where it says time is of the essence under this contract.
9.6.
Yeah, right here. And then it says time is of the essence under this master contract and each contract, including without limitation time for completion of the work. Do you see that?
I see it.
All right. And so you don't disagree with me that under this contract, time is of the essence?
Well, it is stated in the contract, yes, sir.
Yeah, and that's pretty typical for construction contracts that they have a time. A lot of construction contracts will have a time as of the essence clause because they want the contractor to have an obligation to complete things with dispatch and diligence, right?
That's correct.
And in this particular contract, there is a delay provision that expressly says that liquidated damages are available or appropriate if there is a delay beyond the completion date, right?
There again, sir, on the contract in front of me.
Well, it is in front of you. I think if you're at 9.6, there's the same clause that we're looking at here says liquidated damages for failure to complete on time. You're familiar with this contract. That's THB's form contract, right?
Yes.
And in this particular case, the $750 a day was a negotiated amount for contracts that were worth more than $1 million, right?
It was a negotiator, or not, I'm not for sure.
Well, it's a contract that THB drafted, right?
That's correct.
And Mr. Reader accepted this contract and signed it, right?
Yes, sir.
And it specifically says if the contract is more than $1 million, a $750 day charge is appropriate for delays.
Okay.
You do not believe that that $750 a day is a disproportionate penalty, do you?
Disproportionate, what do you mean by that?
You don't think the $750 a day charge is too high? It's in your contract.
Well, it's in the contract, yes, I see that.
The contract that you drafted. Not
Yeah,
maybe
we
you
gave the
personally,
part,
but
yes,
that THB proposed.
that's correct.
So you don't have any dispute with the $750 day amount. Your dispute is whether or not the delay should be calculated from a date certain, because you don't believe there's a date certain provided in the contract.
That is correct. There's not a date certain here.
Okay. And the contract calls for the contractor, that's THB, to provide a progress schedule to the owner, right?
That's correct.
And in fact, in this case, the only time THB provided a schedule is the email that we've been looking at in this case. That's the Exhibit 85 email in January of 2019. You recall that?
That's correct.
And this is the email from your dad. It copies you on it, and he says schedule is below. Right?
Correct.
Doesn't say estimate or doesn't say approximation, right?
Those words are not there. No, sir.
In fact, it says final out April 15th.
That is correct.
And then in Exhibit 134, which is also Plaintiff's Exhibit 134, which is also in evidence, your dad forwards it to BJ Jones. Who's BJ Jones?
She's our office manager.
Okay, so not only did he forward the schedule to the client in this case, he forwarded it internally for the company so that the company would know what the schedule is, right?
Yes, sir. Well, the company is just BJ.
You're keeping a track of the record that there is a schedule that's been sent to Mr. Reader, right?
Yes.
And you intended at the time to comply with that date as best you could.
That was the best idea, I guess, we had to get everything completed at that time.
Okay. Do you think it's fair for Canterbury Cove to expect the construction to be done by that date?
Well, yes and no. A lot of factors out there that causes delays in our progress, material, weather, city inspection plans. So, it's a best guess scenario.
Do you believe it's fair that Canterbury Cove can rely on this date as the completion date?
I mean, I wouldn't rely on it. No, it is subject to change.
What you could have done is sent specific updated schedules and requested the owner to approve extensions of time from this date, correct?
You could have.
You didn't. Right?
You're right. We didn't put anything on paper to him.
And you didn't send him written explanations for why there were specific delays at the time. So for example, you did not send him information, a written excuse saying the junction box issue is causing a delay. We need an excused delay for X number of days.
No, nothing's in writing, but everybody knew the problem was going forward.
What you did provide was what's on Exhibit 60, which is a summary of the delays along with a bunch of weather information, correct? You remember doing that?
That's correct.
And who put that together?
I believe that was a guy named Matt, and he's worked for us.
Matt Kruger, right?
Yes, sir.
He's an accountant.
Yes, sir.
And he said that he thought there was approximately 168 available workdays based on his calculations.
I haven't read through his. Yes, right there. Yes.
It's right there. You see it?
Yes, sir. 168.
Okay. Do you know of those rain days there that are listed, the 37 rain days and the 65 dry out days? Of those rain days that are listed, do you know how many of those days occurred after April 15th, 2019?
I have no idea.
This wasn't provided to Canterbury Cove until towards the end of the relationship, right? When you were having issues in March, April of 2020?
I'm not for sure.
Presumably it was at least after April 11th, 2020, because it calculates workdays here between October 17th, 2018 and April 11th, 2020. Do you see that?
Yes, sir.
It would make sense that this was prepared and provided sometime after April 11th, 2020. Do you agree?
That makes sense.
All right. And of these rain days, you don't know how many of them are actually after the estimated completion date that you provided in the email in January of 2019, do you?
I have no idea.
And this wasn't done contemporaneously with the rain days. In other words, you went back and looked at historical rain information from publicly available weather sources, right?
That is correct.
And it was done not by a person who was on site at the construction project every single day or during the day. It was done by your accountant, bookkeeper, and assistant, Matt Kruger.
That's correct.
And none of these explanations actually explain in any way how the delay that's accounted for here actually caused a delay in completion of the project as a whole.
No, there's
So for instance,
junction box delays.
so for instance,
Delays them out. It doesn't specify on Monday, January 20th, we got inch of rain. We were trying to get this portion of the job done and we couldn't because we had rain that day. It doesn't spell it out like that.
yeah, but it
Other than a
doesn't.
synopsis.
For instance, it does not say the junction box delay caused the delay in the construction project by 19 days because that stopped our work on the eastern side of the property.
No, it doesn't spell it out like that. No.
In fact, there are times and examples of cases where THB was out there working on different areas of the contract at the same time. And just because there happens to be a delay on one portion of the project doesn't mean that the project as a whole is delayed, right?
Well, that one area has been on hold.
For those number of days, but you can go back to it. And presumably if you're doing work on other areas, you have the time.
Well, if you're able to work on the other areas while that one's being delayed, yes.
Yeah. And this particular document that you provided as your written justification for the delays doesn't provide any of that kind of analysis. You would agree with me on that, right?
It could be more detailed, yes.
All right. With respect to the pay application that you submitted with the lien, the number 11. If I can find it, sorry, there it is.
Okay.
You talked about this in your direct examination. This is Exhibit 1. This is the Exhibit A to your lien affidavit that shows the line item, correct?
Correct.
Okay. The first one is Phase 1, $77,470. And then we looked at the pay application detail. Maybe if I can get my thing to turn around the right way. There we go. This was attached to your lien as well, right? These detail sheets.
I believe so. It's hard to read what you're showing me right now, but
Yeah, sorry.
I'm assuming so.
Okay. You just looked at the same thing with Mr. Hayes, so I'll try to,
Yes, sir.
zoom in. So for instance, it has on here an amount for the $21,000 in maintenance bonds, which you didn't ultimately purchase and you're not seeking today.
That's correct.
All right. But in July 2020, you made a claim for it, even though you hadn't purchased the maintenance bonds.
That's correct.
And that's still on file in the public deed records, right?
As far as I know.
Okay. And then there's also a claim here for $37,500 in removal for on-site dirt. You see that?
That's correct.
And that's part of change order number 4.
Like again, it's hard to tell
Remember?
what you see. What I see, I remember talking about with Scott. So yeah.
Can you see that change order number 4 right there?
Yes.
Now, do you know if change order number 4 was actually ever accepted and signed by Canterbury Cove?
I know Bart and I talked about it. I know it had to get done. So the work had to get done to get the project completed.
But you were
That was the cheapest way to get that done.
okay. But were you ever able to get him to sign it because he ultimately agreed with these numbers?
I don't ever remember having him sign anything,
Okay.
but we talked about it on several occasions.
You charged him $37,500 to haul off dirt, but you knew you had to haul off the dirt in the first phase of the project at the very beginning, right?
The job should have balanced. And
Yeah,
we put
so
the
you-
dirt in the back of the job.
So you knew when you started the project that there was going to have to be dirt that needed to be moved, right?
When I started the project, no. The job should have balanced according to the takeoffs that we had provided to us. And it didn't balance. And so they moved the dirt to the back of the job to figure out what Bart wanted to go do with it. The job got completed and we had this big mountain of dirt we had to move.
Right. In phase 1, you did a bunch of excavation and dirt moving, correct? The very beginning
That's
of the
correct.
work.
That's correct.
At that time, you knew that you're going to have to move dirt in the project.
I didn't spend much time out there in the beginning, so I really can't answer that question. But yeah, somebody should have figured that out.
Well, do you remember giving a deposition to me in this case?
I do.
And do you remember being asked about when you discovered that there was going to be dirt needed to be moved?
I don't want to remember that answer.
Okay, let me show you.
The dirt had to be moved.
Let me show you something here. This is from your deposition.
Okay.
And you were under oath in your deposition, right?
That's correct.
And I asked you, when did you discover there was extra dirt that needed to be hauled off? And your answer is, can you read your answer there?
In the beginning, man, I'm not for sure what day it was. It was in the excavation part of the phase. So in the front end of the job.
Answer, yes, sir.
Yes, sir.
And so you knew at the beginning, when you were doing the excavation work at the very beginning, that there was going to be dirt hauled off, and you charged for doing excavation work at the very beginning.
Yes, but that's cut and fill on site, not haul off.
Okay. So
Those scopes of work were already inside our contract.
okay. That was according to you, negotiated with by your dad, right?
Yes.
Now you also talked about this 3,500 PSI concrete of 14,450 in your direct. Do you recall that? Let me get back to
Yes.
that.
It's that junction box issue.
Yeah, you said it was the junction box. Are you sure about that?
Or it could be the extra concrete there on the pavement with the dead end streets.
Well, do you know which one it was?
You pull up here. Oh no, that's going to be on the paving.
Yeah. So the junction
junction
box
box.
was actually paid for in a previous pay application, right? You can see it right here on the third line. Pentagon box, 8x8 junction box, 14,000. Previous amount.
Yes.
So this is something
Yes.
different, right?
Yes, that is correct.
And do you recall having a discussion with Mr. Reader where he rejected that charge on the pay application number 10?
Yes, sir, I do.
And do you agree to removal of that charge?
No, not at all.
Why not?
Because he had to have that concrete in there to let the fire trucks be able to turn around, and also not a fire truck, but for him to have a nice clean break in the phase lines. Even the city inspector agreed with that.
It wasn't a nice clean break though. Weren't they all done in erratic fashion? Like some were longer and extended further than they needed to than others?
Some of them were, yes, sir.
All right. And you already agreed with me that you didn't purchase the bond, right?
Correct.
All right. Now, with respect to the tree issue, you agree with me that THB excavated and bulldozed all the trees out, right?
Yes.
And you agree with me that the contract provides that the THB is to protect the trees.
Vaguely, but going back to that issue though, Bart was responsible and Canterbury Cover was responsible to put tree protection around those trees. And if you look at the excavation cut and field drawings of the plans, there was fills supposed to be made on top of those trees. There's no way those trees would have survived anyways. So they had to go. And if Bart wanted to protect them, he should have put some orange snow fence around them. So, hey guys, you can't take these trees down.
All right. And you don't think that Mr. Reeder and Canterbury relied on or hired THB as its contractor to protect the trees?
It wasn't our scope of work. We don't have a pay item to protect trees. We don't have a pay item to put snow fence up around trees.
Subparagraph 18 specifically requires the contractor shall protect all the trees, right? You see
I
it there,
see
on the
that there
screen?
now. Yes.
And you were given the tree preservation plan,
Yes.
and yet all the trees were removed.
All right, Mr. McCafferty, unfortunately,
sir.
we're going to have to end for today.
I was afraid you were going to say that. I was trying to go as fast as I could. I'm sorry, Your Honor.
It's okay. So let's kind of talk about the schedule tomorrow. How much longer do you have with Mr. Boney?
I'll try to clean it up here overnight. Not that much longer. 20
Okay.
minutes, maybe max.
All right. So we'll start up tomorrow. I do have a 10 o'clock status conference on another case, but we can kind of work through that. Hopefully we'll get the testimony done and then maybe give you guys a break while we do the status conference. So you can do your closings. So for your closing arguments, this is how I kind of want you to structure them.
Mhm.
You each have provided me kind of different elements of damages. I think it's, based on what I've heard, and again, this, I'm willing to listen if there's any case law that comes out there, but I don't anticipate, I don't think, let me just say this. I'm leaning against at this point awarding liquidated damages based on the testimony of the plaintiff's expert and the defendant's witnesses. And so, so that, just FYI, if you really think that's going to be something you want to pursue, then I'm going to need to see some kind of case law, because I just don't see it in this case. But for the rest of it, I'm just going to want you to argue by element of damage. And so what I'll probably do instead of a traditional opening is go through each element of damage that the plaintiff is seeking, and then each element of damage the defendant is seeking, and just kind of see how they all hear argument as to each one, kind of back and forth. And so does that make sense?
I think so.
Yes, Your Honor.
Okay. All right. Anything else we need to chat about? You should have Rhonda should send you a link. I've sent her a link for tomorrow. It will not be this link, and make sure Mr. Boney gets it. And all the witnesses get the link for tomorrow. Tony, I've already sent you the new link. And we will see you, I guess, at 9 in the morning.
Okay.